Imagine a completely routine scenario. You're driving home from work, and you get pulled over for a broken taillight or rolling through a stop sign. In most of the country, this is a minor annoyance. You pay a fine and move on. But for undocumented individuals, this exact mundane scenario serves as the primary pipeline into a multi-billion-dollar shadow prison system. The state justifies the rapid expansion of these facilities as a critical law and order tool. The public narrative frames mass detention as a targeted mechanism designed to protect communities from dangerous, violent criminals. The data exposes this safety narrative as a fallacy. The system operates through the mass deprivation of liberty for nonviolent individuals who present zero threat to the community. This chart visualizes the scale of that operation, showing the more than 70,000 individuals held in federal immigration custody on a single day in early 2026. Look closely at who fills those beds. Nearly 3/4 of that entire population, 74.2%, has absolutely no criminal record whatsoever. For the remaining minority who do have a prior conviction, the vast majority were cited for minor civil infractions or traffic violations. Only about 5% of the people locked in this system have a conviction for a violent crime. The population reached these historic peaks because the enforcement apparatus abandoned targeted investigations of actual fugitives. They shifted instead to massive, aggressive community sweeps. Driven by internal directives demanding 3,000 arrests per day, the agencies operate like an indiscriminate trawler net. They sweep through local neighborhoods and set up traffic checkpoints, capturing everyday people simply to fulfill a quota. When a state rapidly expands its carceral footprint to meet an arrest quota, the human toll escalates. During a 500-day span in this period, 52 people died in federal immigration custody. Independent medical experts found that up to 95% of those deaths were preventable, caused by systemic clinical neglect of easily treatable conditions, like bacterial infections and alcohol withdrawal. The epicenter of this medical crisis emerged at Camp East, Montana, a rapidly procured 5,000-bed tent facility built on a Texas military base. It was here that Geraldo Campos was detained. He was a 55-year-old Cuban immigrant with a documented history of severe mental illness and chronic asthma. He had lived in the U.S. for decades simply because the Cuban government refused to issue the travel documents required to deport him. On January 3, 2026, he requested his prescribed asthma medication. His request was ignored. When he became anxious, private security guards dragged him out of the medical area and threw him into a segregation unit with concrete floors. Detainees in the adjacent cells listened through the walls. At least 5 guards tackled the shackled man, pinned him face down, and placed him in a tight chokehold. He repeatedly cried out that he couldn't breathe before his body went limp. The medical examiner ruled his death a homicide by asphyxiation. In the aftermath, federal agencies and the private contractors issued 4 separate contradictory accounts of what happened, shifting from a fabricated medical event to alleging a suicide attempt. The bureaucracy mobilized to shield its corporate operators from legal liability. How does the government legally hold tens of thousands of people in lethal conditions without charging them with a crime? Immigration detention's civil administrative classification erases Fifth Amendment criminal protections, like the right to a public defender or speedy trial. The government points to internal safety manuals, but federal courts ruled these standards are gratuitous self-regulation, completely unenforceable by the detainees. The legal battle over whether these people possess constitutional rights reached the Fifth Circuit Court of Appeals, which holds jurisdiction over the largest detained populations. In a case called Sosnava-Rodriguez, civil rights advocates secured a brief victory. A panel of judges ruled that indefinitely locking people up violated the Constitution. They mandated a bond hearing within 90 days and ordered the government to prove the detainee was a threat to the community. The bureaucratic response followed just 8 days later. The full Fifth Circuit Court invoked an emergency maneuver to wipe that ruling from the books, instantly vaporizing the constitutional protections for thousands of longtime residents. This civil detention classification functions as a purposeful legal void, engineered to maximize corporate authority and eliminate human rights. This infrastructure draws directly from a long-standing American tradition of state-sponsored captivity. These methods mirror the incarceration of Japanese Americans during World War II. Both systems bypassed standard judicial safeguards, relying instead on broad, status-based captivity without any individualized proof of guilt. Decades of academic research show that punishing entire communities and tearing parents away from children inflict psychological damage that depresses civic engagement and game health for generations. Legal historians draw structural connections between modern civil detention and the 1850s Fugitive Slave Acts. Both enforcement mechanisms legally define a group as outsiders to bypass their constitutional rights. Because modern immigration detention is civil, for-profit facilities utilize a loophole in the 13th Amendment to extract forced labor from detainees. In response, today's sanctuary cities act much like the northern states of the 19th century, passing local laws to resist federal overreach. The lethal neglect and missing legal protections are the predictable results of a machine built to isolate vulnerable populations and extract corporate profit. Aligning this infrastructure with basic human rights requires concrete legislative action. Congress must eliminate private for-profit detention contracts and ban mandatory bed quotas to remove the financial incentive to capture human beings. Lawmakers must also step in where the courts have failed. They must pass statutory reforms guaranteeing a 90-day bond hearing before an impartial judge, placing the burden of proof back on the government. The system must transition away from mass physical incarceration and toward community-based alternatives. These nonprofit case management programs preserve human life, save taxpayers' money, and maintain exceptionally high compliance rates. This carceral industry thrives by isolating its victims in the shadows. Its survival depends entirely on the purposeful removal of its captives from public view. A society's ultimate morality is judged by how it treats its most vulnerable people in the dark. Acknowledging the reality of this system is the required first step in dismantling it.